we're missing Representative Stith. I'm assuming he'll join us momentarily, but why don't we go ahead and call that back to order. For those of you who have a program and are keeping score, the next item was going to be also 039 community-based in-home services program repeal. We've got a change that has now been deleted from the amendment, or excuse me, from the agenda, and we'll not be considering that today. With that, the next item for our consideration on the agenda will be the LSO 403 Chancery Court postponement. Ann, are you going to take us through? I mean, I think we know what that is. That is delaying the bill. Anna, why don't you go ahead and if anything you want to add to that?
Yes, thank you, Mr. Chairman. This bill draft is in response to the Supreme Court's recommended budget cuts. It would amend the time for filling vacancies on the Chancery courts from March 1st, 2022 to March 1st, 2023. I do want to bring your attention to that staff comment. The Blockchain Select Committee sponsored a similar bill, but it changes that date to 2026. And that bill was numbered and it did go to Judiciary yesterday and it came out of Judiciary, Mr. Chairman.
Okay.
And that is the standing committee, the Judiciary Standing Committee.
The Judiciary Standing Committee. Was there any difference other than the date?
My understanding is no. Dawn, do you know if Lily was joining us for this conversation? Because I do know she was at the House Judiciary Committee meeting yesterday.
Oh, there you are. Lily Sharp, it's good to see you. Do you have any, can you enlighten us about your adventures with the Joint Judiciary Committee? You're on mute, Lily.
No, Mr. Chairman, Anna is right that the only change in the bill is that instead of having the governor appoint the full-time Chancery Court judge in 2022, which is what the statute says right now, that bill would change it to 2026. And if you have any questions, I have Claire Smith on here. She's our Chief Financial Officer, and she can tell you any of the financial differences that makes by either going with 2023, which is what your bill says, or 2026, what the House Judiciary says.
Chairman Nicholas, my thought, members of the committee, is there's no sense in replying the same ground if the only difference is the date. That can always be addressed or changed as we move forward. Unless there's objection or further discussion, I would also just delete that one from our agenda today.
I would agree with that, Mr. Co-Chair, although I wonder how blockchain ended up pushing this thing forward.
I have my own ideas, but I'll just keep them to myself. So without objection, that one is now removed. That would bring us the next item for our consideration on our agenda this afternoon would be LSO 229 Veterans Property Tax Exemption. Anna, do you want to take us through that one?
Mr.
Chairman.
Yes, Senator Kinski.
Yeah, you're on a roll. Do you want to go for a triple and just keep pulling bills, and we can have a quick weekend start?
I'm not opposed to that, but I haven't heard any reason to not look at this one at least. So.
All right.
The good news is we're 2 hours ahead of schedule, so keep going. Anna, go ahead.
Thank you, Mr. Chairman. The committee has seen this bill draft before in an earlier meeting, and it was tabled. It's in response to the governor's step 2 budget reduction recommendations that the state treasurer reduce its appropriation for the veterans tax exemption reimbursement to counties by 10%. So you can see that change at the bottom of page 1. It is changing the annual exemption at $3,000 of assessed value to $2,700, Mr. Chairman.
Thank you, Anna. And do we know if this change makes the total amount of expected applications for this roughly equal to the amount that's left in the appropriation, or do we have that information?
Mr. Chairman, unfortunately, it doesn't quite. The reduction in the bill is a 10% reduction, and in order to match the funds available in the budget bill, it would need to be a 15% reduction or a reduction of $450, which would bring the new number on the bottom of page 1, top of page 2 to 2,550.
Okay.
Mr. Co-Chair.
Mr. Co-Chair.
So in our previous meetings, we talked about doing a little work on this bill by adding residency requirements, by adding a means test. And by doing those things, I think we can get to the 15%. So I would respectfully submit that the House would be willing to take this on and make those changes between now and March 1st to get down to 15%, but also to make it more appropriate for, just so everyone doesn't get it. So if it's pending the will of the committee, we'd be happy, if we just want to vote it and send it to us, we'll be happy to do it.
Okay, thank you. Are there other comments or questions by the committee about the bill? There being none, do we have anybody who is waiting or looking to provide public comment on this morning or this afternoon?
Mr. Chairman, I do not see anyone with their hand raised at this time.
All right, with that, committee, what's your pleasure with the bill?
Question.
Move the bill.
Well, we always got to move it first. Then we can do
second.
the then moved, I think it was a move by Representative Larson and seconded by Co-Chairman Nicholas. Thank you. Any further discussion? Let's go ahead and call the roll.
Mr. Chairman, the motion is on 21 LSO 229, working draft 0.3. Representative Kinner.
Aye.
Representative Larson.
Aye.
Representative Schwartz.
Aye.
Representative Simpson.
Aye.
Representative Stitt.
Aye.
Representative Walters.
Aye.
Senator Guru.
Aye.
Senator Hicks.
Aye.
Senator Kinski.
Aye.
Senator Steinmetz.
Aye.
Co-Chairman Nicholas.
Aye.
Chairman Perkins.
Aye.
Mr. Chairman, you have 12 ayes, and pursuant to the prior comments, this will be a House bill.
All right, thank you very much. And thank you, House members, for taking that on. Next item on our agenda for consideration is LSO 365, Medicaid billing for school-based services. I believe we understand this. I think this also bill's been discussed before, but if you want to go ahead and continue with any introductory remarks, either Don or Anna.
Mr. Chairman, I think Ted Hewitt will walk you through this bill. This is a resurrect from 2020 House Bill 119, which was subsequently vetoed by the governor. And I do believe that the Department of Health, if the committee pursues this legislation, has provided a written amendment for your consideration.
Thank you. Ted, go ahead.
Mr. Chairman, excuse me. So as Dawn mentioned, this is bringing back a bill similar to House Bill 119 that was vetoed last year. It would provide certain school districts with the opportunity to bill the state for school-based services. And the process for this would be that school districts would, if they have 25 or more special education students who are Medicaid eligible, they could bill the Department of Health for school-based services. The Department of Health would use some state money and some federal money, and they would provide that to the school district. The school district would hang on to it, and at the end of the school year, they would provide it to the Department of Education. The Department of Education would send that to the state treasurer for deposit in the school foundation program account. And so the basic idea here is to bolster the state treasury, the school foundation program account, through the use of Medicaid dollars to pay for school-based services. And so to run through the bill real quick, on page 2, you can see that 2113-321 is amended. And the first change on lines 11 through 15 of that bill is to allow school districts to be reimbursed for reasonable administrative costs of billing for these services. And so that would be part of the 100% reimbursement for special education costs as this would proceed through the years. Then down at the beginning, down at the bottom, page 2, beginning July 1, 2022, these school districts with 25 or more these special education students receiving Medicaid services would build the Department of Health, as I described. And the rest of this subsection goes on to explain that process of the money coming from the Department of Health down to school districts and then back to the state. Down at the bottom, page 3, subsection J provides that the Department of Education is responsible for calculating how many eligible students a school district has. And so they would determine if a school district meets the threshold of having 25 Medicaid eligible students receiving special education services. This would create a permissive program for school districts to bill the state for these services. It would not be mandatory, and again, it's just for these school districts that meet that threshold of 25 eligible Medicaid students. On page 4, you can see that 424103 is amended, and this sets out the state Medicaid plan. Several services are added here, including the services of a school psychologist, the services of a school social worker, and services delivered pursuant to an IEP. Continuing on to page 5, you can see section 2 would require the director of the Department of Health to negotiate with the federal HHS to change the state Medicaid plan to include these new services. Services of school psychologists, school social workers, and services delivered pursuant to an IEP. Continuing on page 6 and on page 7, you'll see there are a couple sections that provide appropriations for personnel and contract services with the Department of Education and the Department of Health. As Dawn mentioned, the agencies have gotten together and have a proposed amendment to rework appropriations in order to allow for the administration of this program. I'll also note that in the previous version of this bill, House Bill 119 from the last session, there are appropriations for $2.5 million in state funds and $2.5 million in federal funds. And that's the money that would have been used to provide funding to school districts for paying for these school-based services. Because of the timing of this, and because we're in the middle of a biennial period, those appropriations don't need to be in this bill draft, but you can expect that for the next biennium, there would be requests from the agencies to fund those appropriations. Continuing on page 8, section 5 includes reporting requirements for the Department of Health and the Department of Education on the implementation of this program. And then on page 9, section 6 provides effective dates. And with that, Mr. Chairman, I'd be happy to answer any questions.
Thank you. Are there any questions for Ted on the bill? Representative Larson.
Thank you, Mr. Chairman. Ted, if you don't mind again, would you help me understand the school district will submit to the Department of Health for reimbursement for those services, and then take me from there. And then I'm trying to, at the end of the day, you have it going back into the foundation program. Does it come back to the districts? I'm a little confused there.
Right, Mr. Chairman, Representative Larson, so this is set out bottom page 2 and on to page 3 in subsection H. And so the first step in that first sentence is that these eligible school districts bill the Department of Health for these eligible costs for Medicaid eligible students. It's just these school districts that meet that 25 student threshold. And then the Department of Health shall provide payment to each school district, so the appropriated funds come down to the school district. School districts can hang on to those until September 1 of the following school year. And so by September 1 of that next school year, school districts remit the funds to the Department of Education. all the funds that they receive under this program. And then the Department of Education provides the funds to the state treasurer for deposit in the school foundation program account. So that's the process. Does that answer your question, Representative Lawyer?
Well, it does. It does. But then, and then so reimbursement then for those actual costs through the district as the LEA for special ed would come through the traditional, that 100% reimbursement would come through traditional reimbursement then to make up for their shortfall, because they're going to remit everything they got from the Department of Health back to the Department of Education, who then gives it to the treasurer for deposit into the school foundation. Am I understanding that accurately?
Mr. Chairman, Representative Larson, I might defer to the agencies on further questions about this. I believe the 100% reimbursement process for special education services would otherwise remain the same.
Thanks. So we'll do that. We always allow you to phone a friend. I see Trent Carroll just logged on. Members of the committee, just to give you a little bit additional background. This whole concept was one of the studies out of the Efficiency Commission and the consultants of Alvarez and Marcel. This was one of the suggestions they had, recognizing that Wyoming is one of the was, I think, the only state in the union was not getting any Medicaid reimbursement in their schools. We run into some other issues with respect to maintenance of effort. It's something that ultimately would increase over time, but in the first and in its initial has limited value at the beginning. It's something you'd have to do for a few years in order to actually start to realize those benefits if we were to do this. But with that, we'll go to Trent. I think you may have some additional information for us.
Yeah, thank you, Chairman Perkins, and good afternoon, committee. Hope you can hear me okay. And Representative Larson, getting back to your question, you summarized that exactly right. We don't expect there to be any change to the 100% reimbursement. This Medicaid funding would kind of flow separate from that, and that's very intentional to protect us from any kind of a violation with our maintenance of effort requirements that our school districts have for spending their state and local funds on special education and kind of maintaining what we need to for our federal requirements that are attached to the federal IDEA funding that we receive. So Ted provided a great summary of the funding flow as it was proposed last session, and that's where we are today. Happy to answer any other questions.
Thank you, Senator Representative Schwartz.
Thank you, Mr. Chairman. So Trent, if I follow this correctly, there'll be a lag essentially in getting money into the SFP, correct?
Mr. Chairman, Representative Schwartz, that is correct. We anticipate an annual transfer from the school districts just to keep that administrative burden low. So they would presumably receive Medicaid reimbursement from the Department of Health on a regular basis, but they would remit that back to the Department of Education annually.
Is it Representative Schwartz? Any follow-up?
Not at this time. Thank you, Mr.
All right,
Chairman.
thank you. Representative Simpson.
Thank you, Mr. Chairman. Mr. Carroll, you were geared up to do this last year, and so in your thought process, there's a lot of paperwork to be developed and processed. Were you going to be able to manage that internally with your existing staff, or were you thinking you're going to have to add staff to manage the paperwork?
Mr. Chairman and Representative Simpson, I think I'll defer to the Department of Health on your question. We have talked about this at length, and we do anticipate there would be some training necessary for school districts who would be enrolling as new providers. But we have some ideas on how we could implement that, and the Department of Health, could be involved in that, and certainly we would be as well. We would probably also bring in some outside expertise to assist. So maybe I could ask Jesse Springer to weigh in on that question a little bit in terms of onboarding districts and the required paperwork that would be submitted to Medicaid for processing claims.
Jesse, are you there?
I am here, but I can't see myself.
We can't see you either, but we hear your disembodied voice. So go ahead.
Okay. Hi, this is Jesse Springer from the Department of Health. I did turn my camera on, and this is what you get. So we have worked through some discussions with the Department of Education, Chairman Perkins, and we're trying to work through how this could be easiest on the districts and remove some of the admin and looking at some of the software already used by the districts. We think there's an opportunity to make that part of the normal business process, so there's not a ton of extra work. And then they would submit a Medicaid claim. A current vendor that's used by a large number of districts actually does this on behalf of some districts in South Dakota and submits claims to the South Dakota Medicaid agency. And so there's already some things in place that are already used by the districts, and there's just like an extra piece that would need to be turned on. But once that happens, the districts would submit claims. They basically would track their time as they're already doing, and then to the categories they're already doing. And then there's some setup in the back of the system to make sure it gets categorized as a medical claim and submitted to us. So that's the basics of how it would work after it's set up. At the beginning would be, we would need to submit a Medicaid state plan amendment to the federal government, get that approved, get all the mechanisms set up in our payment system, and get this established. So there's a little bit more front end work on this project, but then once it's going, we think, and we've talked through, we think that at least within the Department of Health, we can handle most of the administrative activity with one FTE, and then some changes to the contractual services that were in the bill.
Thank you, Jesse. Representative Simpson, any follow-up?
Oh, very good. Thank you, Mr. Chairman.
Thank you. Any other questions? Any other questions? We've got Stefan's listening. I don't know if Stefan has anything to add, but if that's it, there's no other questions. Committee, is there any public comment on this bill today? Karen, do we know? Do we have anybody out there?
Excuse me, Mr. Chairman. We do have Ken DeCaria, and after we hear from him, I believe we will hear from Mr. Denning.
Okay, thank you. Ken, are you there?
Good afternoon, everyone. Mr. Chairman, I wasn't going to testify on this bill. There was another one that I was interested in, but Mr. Chairman, I think school districts would be okay with this as long as, and those provisions are in there as to deal with the cost and the resources, because some districts just wouldn't have those resources in order to do this. Mr. Chairman, we'd also prefer it if it was, permissive, and I think as I read most of it, it is. We've had a couple, we did have, at least I know one district that was volunteered to do a pilot on this just to see how it all work and maybe work out those bugs, Mr. Chairman. But with that, happy to answer any other questions. And Mr. Chairman, I really signed up for a later item.
Okay, thank you, Ken. It's always good to see you. Former Senator Ken DeCaria. Thank you. And we had one other person who else was lined out that somebody else going to speak to us, Karen?
Yes, sir. I was expecting to hear from JP Denning.
Mr. Denning, are you there?
Yes, I am. Can you hear me?
Yes, go ahead, Mr. Denning. We can't see you, but we can hear you.
Okay. Very much appreciate the opportunity to speak on this. Appreciate your work on the issue. I understand the additional updates. So, I guess I still continue to have some concerns about it. So, just from the school perspective, I understand the need for funds, and we were one of the districts that had volunteered to, be open to pilot something. And so I think we're trying to approach it with an open mind. So I think the updates are, some steps in the right direction, but there's still some outstanding things. So parents have a limited number of units, and anytime a school is using the units, that would affect the parents' ability to make medical decisions on behalf of their children. And so that kind of puts us into a different role than just simply as an educator. So be aware of that. And then every time we understand that every time we would use a unit, so let's say we're meeting as a team and we identify that a student is in need of speech or language services, that the next step would be, so typically then in an IEP process, then you identify those services, the amount, the frequency, visit with the parent, and you're set. In the process with Medicaid, what we would have to do is we would have to do a timeout stop, and then we'd have to say we have to visit with a physician or medical provider who would then prescribe the service, and then we'd get that prescription back. Then we could sit down with a speech pathologist and say, let's provide those services. And so it just begins to interrupt the flow of the IEP process. I think it makes it less efficient for the staff that we're all paying for as citizens of Wyoming, and then less efficient for parents. So it just introduces those things. Just in thinking about other options, so wonder if there are some options to explore on maybe expanding some of the existing things. Like one of the wild cards in our special education funding is school district placements. And so perhaps there's a way to partner the use of Medicaid funds with placements. It's been my experience as a director. I've been a director for several good number of years in the school district, that many times there's a lot of situations involved, and sometimes, very often medical need is one of those components. And so it seems like it could be a warranted use and could offset some of that cost that we're paying for with state funds. Another idea would be to look at the early childhood. Our early intervention efforts have been reduced. School districts are feeling the effects of that reduction, not necessarily in terms of needs, so we still have about the same number of students identified, but the needs have greatly increased. So the gap between where they are and where they should be has grown because of lack of early intervention. Maybe there's a way that our Medicaid funds can be partnered with our developmental centers to provide more service. Currently the 0 to 3 model is kind of medically driven, but maybe there's another way to do that. The last idea, and then I'll take any questions, is to expand options for parents 18 to 21 with the developmental disability waiver. We do hear reports from parents that they cannot move on to the adult waiver until they're 21, and that they would appreciate some flexibility if the family and young adult was ready to transition at age 20. They might like the opportunity to start participating in that. Right now, parents don't have that option, and then school districts bear all of that responsibility until 21. I want to provide the support no matter what. It's just kind of a matter of where you're moving the money from. Those are all my comments. Let's see.
Thank you, Mr. Downing. Anybody have any questions for Mr. Downing? Senator Steinmetz.
Thank you, Mr. Chairman. I just wondered, could you elaborate again on the parental role if we would make this move? You mentioned some things that were a little concerning.
So a parent has a certain number of units available for Medicaid services. And so right now the parent is in control of making those decisions on how to care for the medical needs of their children. In this model, it would involve the school district kind of using up some of those units for the parent. And so it would change the parent's ability to access medical care for their child. And it would put part of the conversation that schools have to have then is, a different relationship with a parent.
Thank you. So Senator Hicks?
Yeah, Mr. Chairman and JP, that I think that illustrates part of the concerns that we have. We have ample anecdotal evidence that people move to Wyoming just for that very reason and enroll their kids into the public school system. And in fact, I know at least one or two school districts on the border of the state this year saw substantial enrollment, so those parents can keep 100% of their benefits. And then because it doesn't encroach upon the federal, then the state pays 100% on the school side. And so how do you address that issue as far as a parity? And do you see that? Because we've certainly seen some anecdotal evidence of that fact.
Mr. Denny?
Chairman Perkins, Chairman Nicholas. I would say in Cheyenne, I don't really know of any anecdotal stories like that. We certainly in Cheyenne have a lot of families moving to us, military connected, and as a result of that. And so that's probably the most of our out-of-state transfer population. We certainly want to have our best services in place for those folks. So I don't know that I am aware of any anecdotal things like that, but yeah, that you're presenting, that's the concern, that parents lose some of that ability to make those medical decisions.
Thank you. Mr. Denning, out of curiosity, at the end of the day, a lot of the services particularly for severely handicapped in the schools with our IEPs do by their nature though include in many instances substantial medical services for those children while they're attending school. Is that not correct?
Chairman Perkins, so yes, indeed, they are services that are provided by speech pathologists, school psychologists, occupational therapists, physical therapists, vision therapist, etc. Those are not necessarily considered medical. There's a definition of medical that does limit it to doctor prescribed. And so it might be the same service, but if you do it in a medical profession, you have to do it one way through a doctor. And IEP services, we do it as an IEP team.
Okay, thank you. So let's see, who else? Representative Larson.
Mr. Chairman and Mr. Denning, I'm a little confused because you talk about taking away some of the parents' ability to decide, but I thought the whole intent of an IEP, even though you have a team, the parents are the critical component of that team in determining what services their child would get. Am I mistaken on that?
Chairman Perkins, you are correct. In an IEP process, the team makes the decision, and the parent is an integral part of that.
So follow up, Mr. Chairman.
Yes, go ahead.
And so with that understanding that the parents are a critical part of that team and a critical part of that decision, and some of those services that would be then being provided for that child could be Medicaid reimbursable, it seems to me that they would still indeed be part of determining the use of those services. And the cap on the Medicaid services, although there may be, for example, a limit of 20, say, for speech therapy, but that's not a hard ceiling. If a medical professional then determines that restorative services need to continue on, they can get additional services. Am I mistaken there?
Mr. Denny?
Chairman Perkins, we understand for Medicaid reimbursement, there are a limited number of units. And so a great question, Representative Larson, that the problem would be a parent might say, I'd like to use those services to work on speech for a specific goal or specific category. And the school district might be saying, no, we need those services to work on, school-based things. A parent might be interested in, I want to build the student's ability to visit with their grandmother or with their grandfather, and the school might be saying, no, we want to use those units. And so it sets up, you've got a certain number and you've got to pull this way, pull that way. Ideally, yeah, some of those might completely match and there wouldn't be that, but there's the potential that it could be, we would be competing with parents for how they use their, what's been considered a medical and parental decision.
Mr. Chairman, one last follow-up, if
Go
I
ahead.
may, because that's not making sense to me. Because if the parent is a critical component of that IEP service, why then would the school be in conflict with the parent? That should never happen.
Representative Chairman Perkins, yeah, we hope that doesn't ever happen either. But a parent might say, no, you can't use those services. And then that kind of eliminates the Medicaid reimbursement.
Okay, thank you. That's it. I've got Jesse would like to, I think Jesse Springer has got his hand up. So Jesse, go ahead. Can you help us?
Chairman Perkins, I think there's some misunderstandings here. So first off, the services provided in the school, most likely we would exempt those from any limits that exist. And most limits don't exist on children in the first place. So most of the limits that exist are on adults. So what we're talking about here are primary medical state plan services. So like in the Medicaid world, there's a base plan, and then there's waiver services, which add on to those, which are for the support waiver and the comprehensive waiver if someone has intellectual disabilities or acquired brain injury or something like that. But we're talking about the base services here. And so we would not, and we still need to design the program, obviously, because it hasn't been passed. But as part of this state plan amendment, we would exempt this from the limits that were being discussed. So the services provided in the school likely would not be subject to limits or to prior authorization, and they would be like in a separate pool. So the parents would still have all the control over the regular pool of services they have that would be outside of the school. And then if we see a bill come in from a school district, which will have a specific medical taxonomy, then we can exempt them from all sorts of things. So it wouldn't be pulling into the limits. It wouldn't be pulling into prior authorization if certain services require prior authorization. And most of those are not actually subject for children anyway. And so I think some of the discussion might be pulling into like waiver services, but that's not really pertinent here because we're not really thinking any service at the school is a waiver service. We're really looking at physical therapy, occupational therapy, speech therapy, behavioral health, school nurses, school psychologists, school social workers, and physicians if a school district employs a physician. Those are the type of services. So there is an authorization form that is required to bill Medicaid that the school districts would need to collect upfront, likely every year, I think would be a good practice. We know it has to happen at least once, and that parent has to give authorization for the school district to bill on behalf of the services they provide. But and that's actually required by education type federal regulations, not Medicaid. But when we worked through this, that was we weren't envisioning that they would be going into any limits or anything like that. That you wouldn't be cutting into like 20 services that they can get without a prior authorization.
Okay, thank you. I think that was helpful, Jesse. Other questions for any of the committee members? Any other questions like that? Senator Hicks, did you raise your hand, or was that just your? All right. Okay, thank you. I think is there any other public comment that you're aware of, Karen?
No, sir, I don't see any other public comment.
Okay, we'll go ahead and close off public comment for now then. Mr. Co-Chair, I think this is one of those similar to what you did with the veterans property tax. I think there's some work to be done on this bill. We can move it forward and we'll go ahead and look at those proposed amendments and things like that as we get ready for the March session, assuming that comes off on as planned. Representative Stith.
So, Mr. Chairman, I would move the adoption of 21 LSO 365 Medicaid billing for school reimbursable services.
We have a motion by Representative Stith and a second by Representative Kinner. Thank you. Any other question or discussion? Let's go ahead and call the roll then, please.
Mr. Chairman, members of the committee, the motion is on 21 LSO 0365, working draft 0.5, Medicaid billing for school-based services. Representative Kinner.
Aye.
Representative Larson.
Aye.
Representative Schwartz.
Aye.
Representative Simpson.
Aye.
Representative Stith.
Aye.
Representative Walters.
Aye.
Senator Guru.
Aye.
Senator Hicks.
Aye.
Senator Kinski.
Aye.
Senator Steinmetz.
Aye.
Co-Chairman Nicholas.
Aye.
Chairman Perkins.
Aye.
Mr. Chairman, 12 ayes.
Thank you.
This will be a Senate file.
Thank you. Next item on our agenda for consideration is LSO 336 Wyoming Tourism Account Revisions.
Mr. Chairman,
Mr. Chairman.
We'll go with Mr. Vice President first here. We'll pull
Mr.
rank.
Chairman, could we do a quick breakout session on this?
We can't do breakout sessions. Can
We can't really do a breakout session. We'd have to set up a separate Zoom session, I think,
I
or
thought
set up
I can do it.
Teams.
I can do it by Teams. I've got a Teams for the Senate approach set up.
Yeah, I
I
thought
can send
Sharon,
that to you.
Sharon was going to get something set up over the lunch hour in case we needed to do that.
So, Mr. Co-Chair, before we do that, I think we had one major question in this when we were looking at this bill, and that is the fiscal impact of.
Somebody mute yourself.
So who was speaking? I thought Co-Chairman Nicholas was talking, wasn't he?
Yeah, I had a question before we go on to breakout, and so originally we thought this would assist. It would just begin the funding earlier, but if that's not the case, that was the whole purpose of this bill, was to begin using the funds as they're accruing now to begin covering costs. But if the way I understand it, as we kind of relooked at it, is that if we spend the funds now for like the rest of the biennium that is coming in through the lodging tax, then there won't be anything left in the account, or not much, the next biennium. It would only be kind of that part of the reserve account, which would mean that we would have to advance fund perhaps some monies in the initial part of the biennium with other funds in order to capture any obligations or any contracts signed by the Department of Tourism. So I'm just curious if that's the case, and exactly how this will impact, how it'll catch up with itself so it's self-funded and we don't have to pay any dollars out of our pocket in order to cover all of their ongoing obligations. Because if we do, I don't know if we want to do the bill. That's my point.
Okay, and so Don, do you have the answer for that to Co-Chairman Nicholas's question?
Mr. Chairman, as the statute reads currently, you would have built up a decent sized corpus from which the Board of Tourism could be funded in the 23-24 biennium and not have concerns as to cash flow. Under the current draft, you would move forward the use of those collected revenues, and it would cause potential challenges with respect to available funds. Now, almost every other agency operates this way, meaning they are spending current revenue as they are collecting it. Think about the family medical residency centers, think about the livestock board, they're collecting fees and using it for their operations. But the delay in the appropriations, which was the original statute, provided about 18 months of comfort to build up some reserve in advance, and that would go away under this legislation.
Okay, thank you. Senator Hicks, does that change your request at all?
I don't know. I'm looking at my Senate colleagues. I'm more inclined just to set this bill back. I think there's other associated risks out there, regardless of what the funding stream is. I would just tell you, I think if you bring this bill into the Senate, you have a serious chance that you may lose the lodging tax by bringing this bill in. When I sit there and I've seen the shift, so that's a risk that you would run bringing this in there. At the end of the day, it's either going to go into account or come out of general funds where the tax dollars or lodging tax are flowing right now. I just don't see this as a vehicle that runs the risk of losing that lodging tax that we'd want to run through the Senate right now.
Okay, well, Senator Kinski.
Mr. Chairman, I guess I'd defer to the lawyers to see how realistic a prospect that is. The bill opens up just a section about the distribution, not the creation of the tax in the account itself, the way I read it. But if there were an amendment brought to completely repeal this lodging tax act, would that be germane to the bill?
I think the title says lodging tax.
An act relating to revising the operation of the account in the Wyoming Tourism Reserve and Projects account.
Mr. Chairman, I would just move that we table. So.
Okay, we've got, there's a second from Senator Guru.
Yeah.
Is there further discussion on the motion to table this bill indefinitely? I'm assuming that's the motion, table indefinitely. Okay, thank you.
Call for the question.
Okay, call for the question. All those in favor, please raise your hand. Voting appears to be unanimous. Was there anybody who was opposed? Okay, that motion carries, and that one is laid back indefinitely. I know that our good director of the Board of Tourism has been on a long time, so sorry, but you probably don't have to talk now unless there's something you need us to be aware of. So I have the next item on our agenda is LSO 364, Local Impact Assistance Payments and Industrial Sliding Division Funding and Fees. Ted, are you going to take us through that? I see you on there. Is that you or is it somebody else? Okay, go ahead.
Thank you, Mr. Chairman. So this is 21 LSO 364 and relates to the state's impact assistance payment program to compensate local governments for the costs of industrial facilities in their communities. So the bill amends two sections of law, 3915-111 and 3916-111. The first is the state sales tax, the second is the state use tax, and the amendments to the two sections are the same. So I'll go through the first one, and that should cover the impacts of the bill. So on page 3, you can see starting on line 12, there's an amendment to how the Industrial Siting Council is to make determinations about the value of the payments. So under current law, the council has to state the reasons for determining the amount of the payment. And you can see language is added that would require specific findings of fact for the total dollar amount determination. So that's the first change. Next change is down towards the bottom, page 3. These payments under current law are limited to 2.76% of the total estimated material costs of the facility. The bill draft would reduce that down to 2% of the total estimated material costs of the facility. Next, on page 4, on lines 5 through 9, you can see language is added, and this goes to the council's determination of a ratio about how payments are to be divided between the county and cities and towns that are impacted by the industrial facility. And so this new language provides that in determining this distribution ratio, the Industrial Siting Council may consider the extent and location of unmitigated impacts, the populations of the local jurisdictions, and any other equitable factor. And there's a staff comment on page 5 that highlights that this is a may, and the committee can consider if it would like to make that mandatory by changing that may to a shall. Next, on page 6, you can see the definition of unmitigated impact is added. And so this is in determining the distribution ratio. Unmitigated impact means expenses incurred by a local government directly attributable to the construction of the industrial facility. It's an expense that is not mitigated by any other entity, and it's for medical services, fire and law enforcement services, roads, and public utilities. The definition of unmitigated impact specifically excludes a couple things, and down at the bottom of page 6 and on to page 7, you can see those exclusions. And the first exclusion is to remedying or improving existing facilities beyond what they were prior to the construction of the industrial facility. So improvements are excluded from this. And then additionally excluded are expenses for which a county, city, or town previously received an impact assistance payment, unless the county, city, or town can demonstrate that the expenses are new or ongoing. Then down on page 7, you can see 3916.111 is open. That's the state use tax distribution provision. And the same amendments are made as in the prior section of law. On page 11, section 2 makes this prospective. So this won't impact impact assistance payments that are already set. And there's an effective date of July 1, 2021. And with that, Mr. Chairman, I'd be happy to answer any questions.
All right, thank you. Questions for Ted? Ted, a quick question for you. As we look at the definition of unmitigated impacts, and looking at that, you're kind of looking at it. I don't even know if it's implied, but ultimately, you know, when you have industrial siting commission, it's going to provide some additional tax base in the form of ad valorem taxes in the local communities or the counties, as well as potentially sales taxes or other things dependent upon exemptions and whatever. So when you have those anticipated increases in the tax base and anticipated revenue that appears locally, is that taken in the definitions and the way we have this drafted, is that taken into consideration? Is that a mitigated impact to the extent that there is additional anticipated tax revenues, or is that still still unmitigated?
Mr. Chairman, I don't want to guess, and so I'm not sure, but we can certainly find that out.
Okay. All right. Thank you. Any other questions? Representative Schwartz.
Thank you, Mr. Chairman. So can you help me, Ted, on what the timing of this would be? Because I recall conversations many, many years ago with the counties on this, where one of the issues was that the costs come in before the money. And I don't see anything that refers to timing in here, but I might have missed it.
Mr. Chairman, Representative, that there is a reference to timing in the section 2 in terms of the applicability, but in terms of the when the payments start, I have to admit I'm not sure when the payments start.
Follow up, if I may.
Sure, Representative Schwartz.
Thank you, Mr. Chairman. So conceivably, there are significant costs. Let's just talk about roads, for instance, bridges that could devolve to the locals prior to any payments.
Well, and as I look at that, I see Todd and Todd Parfit, Director Parfit, and I think Colin is one of his folks, and maybe they can help you with, they may be able to help us with that. Todd or Colin, can you help us with Representative Schwartz's question?
Thank you, Mr. Chairman. I'll start, and then maybe Colin can clean up where I don't quite get everything complete here. But that has been historically, Representative Schwartz, one of the concerns with the impact assistance money. As you said, it often comes after the impacts are realized, and that's something that I would agree isn't specifically called out here. But typically what happens is once the company begins construction, we notify the Department of Revenue. And then the Department of Revenue distributes according to the Industrial Siting Council's distribution ratio to the county treasurer, and then the county treasurer distributes to the municipalities and the other counties.
So Representative Schwartz, any follow-up?
Yeah, thank you, Mr. Chairman. I'm not 100% sure that really solves the problem I'm concerned about.
Well, yeah, I think he admitted there's a delay problem there. Yeah, so it doesn't solve that problem. This bill's not gonna, in its current form, isn't gonna accelerate that. Senator Hicks, did you have a comment?
Question for Todd. So when the industrial siting division and the county cities come and then they present, and it's a maximum of 2.76% of the sales. So they come and present, and then the council makes a determination. So what happens if the council, so let's just do a hypothetical that there was potentially 10 million available for local impact assistance. The council only grants 8 million. What happens to that other 2 million? I'm assuming that stays within the state's coffers as part of that percentage of that sales tax. Is that correct?
So, Mr. Chairman, Senator Hicks, that is correct. There's no distribution of those funds until we notify the Department of Revenue, and then they make the disbursements based on the initiation of construction in accordance with the way the Industrial Siting Council has determined the distribution should be. So the money, if it has been collected, would reside within the general fund, the coffers, until such time as that call on the money is made.
Follow up, Mr. Chairman. Todd, I know a year ago that you and the Department of Revenue had presented this, but and I don't have that show of how much the council had granted versus how much was available in the last few years. Do you have those numbers?
Yes, Mr. Chairman, Senator Hicks. Yes, so for the projects that were approved or permitted in 2018 through 2020, the percent of the maximum allowable that has been awarded is 65%. So in dollar amounts, the maximum impact assistance that was available at the 2.76% was 126 million for those projects. And the Industrial Siting Council awarded distribution of 78 million, which equates to 65%.
All right, thank you.
Okay, thank you. Yeah, go ahead, Mr. Co-Chair.
So spoken in a different way to phrase it, we've lost 78 million in impact assistance would otherwise go to the general fund in 2 years. Is that right?
To the way around, I think. Go ahead, Todd.
Yeah, so Mr. Chairman, Mr. Co-Chairman, yeah, so we had 13 projects in that time frame, and it's 3 years, so 2018, 19, and 2020. So that 78 million is the state share of the sales and use tax associated with that project that would otherwise have remained in the general fund. So that is correct.
And my understanding is, Mr. Co-Chair, just a follow-up, is that prior to about 4 years ago, 5 years ago, and there was a sheet that was passed around that, I mean, typically we were giving out $1 million or $2 million at most. And last year we gave out 30 million. I mean, so this whole concept has ballooned into a significant impairment into our collectible tax revenues, and the anticipated costs in the future, the next 5 years, are with projects on the block are another $50 to $100 million in sales tax revenues that the state will be forfeiting. Is that right? Or just getting over for local impact assistance?
Todd, if you know.
So I'm sorry, I'm not sure I understand the question, Mr. Co-Chairman.
Go ahead, Mr. Co-Chair.
Sure. So the question is, Todd, my understanding is there's numerous projects on the drawing board that if we continue to do the 2.76% for local impact assistance, it will be a substantial amount of monies that would have taken away from state coffers. In other words, our share of the sales tax of those properties. And those are 50 to 100 million bucks worth of revenue that we're going to lose and be directed to the local impacts.
Yeah, so Mr. Chairman, Mr. Co-Chairman, what I can speak to is what is projected for this coming year, 2021, based on projects that have come in for jurisdictional meetings. And we're looking at about, for 2021, an estimated distribution of up to 10 million. Beyond that, I'll have to turn to Colin McKee to see if he has any ideas on beyond 2021, what the projections are.
Go ahead, Colin.
Yeah, thank you, Mr. Chairman and Mr. Co-Chair. Yeah, so as Director Parfit had mentioned, we do have a few projects that we have I guess, high level of confidence that will submit an application this year. We have 4 that we're, fairly confident on. And then, and as Director Parfit had said, so the maximum amount of impact assistance available will depend on what the material costs of those projects are. But right now we're looking at possibly a new trona mine outside of Green River, a couple of large-scale wind projects, and a utility-scale solar project. And from there, I guess in the next few years, most projects seem to be centered around Rocky Mountain Power's RFP to procure new renewable resources. And we do expect a lot of those projects to land in Wyoming.
Okay, thank you. Senator Hicks, did you have your hand up a minute ago? Go ahead, Senator Hicks.
No, I was just gonna reiterate, or I guess enlighten that the information that we had been presented in the past is the Industrial Siting Council has historically, so let's go back maybe 7, 8, 9 years ago, pretty much awarded about 100% of those impact assistance funds. And what we've seen in the last 3 or 4 years is they really tightened up based on what was the actual need of those. So I think the Industrial Siting Council has done a much better job on these latter 3 or 4 years of projects than they did historically. So again, I think the numbers that Director Parfit threw out there, that they're only distributing about 65% out of that 2.76% of sales tax. So I think they've done a pretty good job in the last few years of restricting how much money to actual needs of the cities, towns, and counties. But that's my recollection of the distributions over, say, the last decade or so. Did I mischaracterize that, Director Parfit?
So, Mr. Chairman, let me just give you a little bit of historical context. Up until about 2016 or 2017, the distribution of impact assistance was on a different formula.
Okay.
It was on a formula that was based on, it still was paid out of the state's share of sales and use tax. So it still was coming out of the general funds from from the state. But the difference is, rather than the formula being based on the actual economics of the area, it was changed to the 2.76. And I think it was 2016 or 2017 when that came into play. Senator Hicks is correct that I think in the beginning period of the use of that new formula, more of the monies were distributed at the full amount of the 2.76, but the council has in recent times done a better job of taking a closer look at these projects. Not that they weren't before, but in terms of trying to decide what the real unmitigated impacts were. And that's why this is important. I think in the draft bill, it talks about, it defines the unmitigated impacts and provides a tool for the Industrial Siting Council to use.
Thank you. Representative Schwartz.
Thank you, Mr. Chairman, for indulging me again. So following up on Senator Hicks, so assuming that the standards that the council is using to gauge what the impacts are, and we lower from 2.76 to 2.0, do you think there's a potential that we would actually have a situation where the estimated cost won't be covered by that 2%?
Todd, if you know.
Mr. Chairman, Representative Schwartz, I don't really have a good guess on that, but I'll ask, turn to Mr. McKee to see if he has some thoughts.
Yeah, Mr. Chairman and Representative Schwartz, I thinking of a way to characterize this. I would say for every project that comes through, I mean, there is the maximum amount of impact assistance available. And when the communities, I think the communities do a lot of belt tightening in identifying what their primary impacts of concern are. And so I think, the communities, I think, they'll have the same impacts regardless of, if there's 2.76% available or 2% available. They'll just have to prioritize a little bit more on what they think is the best.
Okay.
Mr. Chairman, if I may.
You go ahead, Director.
And just one other thing is that, and I think if you look at, as we pointed out earlier, of the 2.76% that's been available for projects over the last 3 years, we've seen communities be awarded 65% of that 2.76. So I'm not sure that it would be a significant issue, because of the roughly 124 million that was available, 75 million was distributed for impact assistance.
Okay, thank you. Senator Hicks.
Yeah, Mr. Chairman, just to follow up on that, Todd, though, well, one of the things that I think you need to take into consideration in that 65% distribution formula, that many of these projects happened in the same localities. So they received impact assistance funds in 2018 that may have mitigated a lot of that. So they're not coming back for the next go around and the next go around. So while that 65% has mitigated those projects, you go out to a county or an area in Wyoming that has not had an industrial siting project that's already built their water, sewer, ambulance, police, law enforcement, and all those services up to deal with that. You very well could run into a situation where the 2% does not cover those unmitigated impacts. Where we have multiple industrial sightings on top of themselves, I think that would probably adequately cover their expenses. But if the council's already doing that, why would we restrict those communities that are going to have industrial impacts that have not had multiple projects already? And I guess, Todd, would you characterize that as accurate with what you guys have seen with these multiple large projects in the same geographic area?
Yeah, Mr. Chairman, Senator Hicks, absolutely. That's a good point to bring up. Where there are multiple projects on top of each other, a lot of those impacts have already been addressed under a different project, which then drives down the amount of impact assistance needed in new areas of development where they haven't had previous projects. I would agree with you that, yes, their amount of impact assistance would be greater than on some of those multiple project areas.
Thank you. Other questions? Mr. Co-Chairman.
Thank you. So, I mean, I recall when we modified the formula for impact assistance, and the argument was perhaps we weren't paying enough in impact assistance. That's my recollection. And since we did modify it, the amount we paid for impact has more than quadrupled. I mean, and Don, if you could probably run through those numbers, we had a handout on what it was over the past 10 years, but it has gone up tremendously. And I remember Senator Beba saying, wait a minute, you're getting brand new windmills, you're getting all these things that add to the value of your county, and yet we're paying you more, even though you're filling up your restaurants, you're filling up your motels, and you're receiving all these benefits. These are exactly the business development things that every county prays for. And now we're giving additional dollars in order to impact what's happening to your water, sewer, and those impacts, even though, and there's nothing wrong with that, except that we have to recognize that we are short on the state side. And so we're giving away tens of millions of dollars of revenue that a lot of it goes right back to the counties, but on a different portion of distribution. But I think we have to recognize that when we modified it, all of a sudden there's a lot bigger pie of dollars to pick from. And my understanding, if you talk to some of the members of the board that allocates the money, some of them, I mean, they want to give away as much as they can. And now that there are more dollars available, lots more people are lining up because there's a bigger pie to pick from. And I don't think we're recognizing the impacts of modifying that the number of dollars available and the criteria for it. And we are, and it may be useful to the counties, but to me, it's a quid pro quo. If we're cutting back on lots of other benefits that we're paying out and we're cutting our budget by $500, $600 million, then is it appropriate that we shouldn't as well cut back on the impact assistance, because those are the dollars that we use to cover the general operations of government. So Don, do you have those numbers on the difference of what we paid out in the large increase over the last 3 or 4 years?
Don, go ahead if you know.
Mr. Chairman, members of the committee, let me just talk about these in reverse. So in fiscal year 20, the state paid out $30.3 million. In fiscal year 2019, the state paid out $10.85 million. And those were the two largest in the last 15 years. Fiscal year 2018 was a little 255,000 rounded. Fiscal year 17 was just 34,000. Fiscal year 16, 635,000. Fiscal year 15, 977,000. Fiscal year 14 is one of 2 fiscal years prior to fiscal year 2019. There was a substantial sum, and that was $5.3 million in 14. In fiscal year 13, it was 132,000. Fiscal year 12, there were no payments. In fiscal year 11, the payments were 781,000, and fiscal year 10 was the second of 2 years prior to 2019, with the distribution in the millions at 2.2 million.
Okay, thank you, Don. So members of the committee, other questions? If there's none other, we'll go ahead and open it up to any public comment. We've got, Todd, do you have anything you'd like to add?
Mr. Chairman, no, but we'll stay around for additional questions.
All right, thank you. Is there Karen, who else do we have? We have anybody else in the that's lined up to do public comment on this bill?
We have one party that we have invited into the room, and that is Jeremiah Ryman.
Sure. Okay, Jeremiah, hi. Go ahead.
Good afternoon, Mr. Chairman, members of the committee. I am Jeremiah Riemann here on behalf of Wyoming's County Commissioners. I appreciate the opportunity to address this issue. Mr. Chairman, I do have comments relative to this bill as well as the second. I can do them both at the same time. I can come back for Senator Hicks's bill later as you see fit. Mr. Chairman, certainly appreciate the conversation today. I think a lot of this has been characterized as local impacts. That's certainly how the program is structured and stated. But I think it should be looked at perhaps a little bit differently. We're really talking about state impacts that are addressed and implemented locally. And just to give some example of what I mean by that, here in Laramie County, just recently, we've had two rather large wind projects developed. In that instance, the county identified that area, and this could apply in many other areas. I'm certain Senator Hicks has similar examples, but in that area, it was void of communication facilities, void of medical emergency and other public safety systems. The county, as part of this process, ultimately asked for funding to install a Wyoming tower. Yeah, that was a benefit to the county and the communication system here, but Wyoming is a statewide priority and has benefited others. I also want to state that higher payouts of recent mean a couple of things. It means that there are more and generally what we've seen, much larger projects that are happening. And as a result, the impacts do accrue from there. As has been stated in some of the testimony here, counties are cognizant of their responsibility to try and ensure that they bring forward appropriate projects for consideration. And I think that by and far, they have done that. That's not to say that there haven't been some hiccups. And my members would tell you that there are some areas of improvement that could be had in this program. The first area where there's a significant need is around accountability. We need accountability really in two areas. One is with the Industrial Siting Council itself. I would say that many of my members would tell you that they feel often that the council makes rather arbitrary decisions and would cut projects directly in half without giving any adequate justification. I think that the bill that has been put forward here helps in that regard. It does have a provision that the council would have to give fact and finding about its decision. That will help my members, and we appreciate that. We also think there needs to be local government accountability. Currently, the system doesn't really, in any regard, require cities, towns, or counties to report the expenditures that they've had, or frankly, to come back and return monies that haven't been expended. I don't think that that really applies to any of the counties, but I know that my members would tell you that they could show you examples where some of our cities and towns have not actually acted on the projects that they put forward, and that's inappropriate. We need to address those things. Perhaps that's done through rule and regulation. Maybe that's done through statute. The other place that my members would tell you we need some solid action is through a definition of unmitigated impacts. That will both help local governments in making their applications so that they're not asking for things that are outside of the intent of the statute. It would also help the Industrial Siting Council as they go about their work to ensure that they're giving adequate consideration to the projects that are put forward. Mr. Chairman, again, I do think that this bill takes a step forward in that regard. Some of my members would tell you that they'd prefer that definition of unmitigated impacts be done through the rulemaking process at the Department of Environmental Quality. Others would say it's okay to have some basic structure in the statutory language. Nonetheless, a definition is needed. I will say that my members have previously opposed such a dramatic cut to the amount of available impact assistance. They have felt that they've tried to come in with reasonable and appropriate projects, and as the data shows, that's generally come in around that 2% level. Nonetheless, there are times when it's appropriate to be above that 2.76, or sorry, the 2% threshold that is there, and perhaps even going up to the 2.76%. I would expect, we haven't taken a firm position on this bill only because it just came out, but if this bill moves forward, I would expect on that grounds that the commissioners would oppose that provision in particular. But I'm here and happy to continuing working with you to find ways to address the budgetary concerns that many of you have. We know that there are some spaces there to work. Mr. Chairman, we have a couple of other things that I think we would bring forward at the appropriate time with the bill, but certainly understand that that could happen at a different time. Mr. Chairman, that really is my comments relative to the Industrial Impact Assistance Payments Bill. I'm happy to go to the other bill if you'd like now, or come back.
Why don't we wait and come back on that?
Okay.
Okay, thank you. Senator Hicks, questions for Jeremiah or others?
Yeah, Mr. Chairman, just question for Jeremiah. Have you looked at the definition in here and for unmitigated impacts? And is there anything in there that is currently, or is there anything that's been funded that's not in the bill through the Industrial Siting Division? I guess I'd ask Todd the same thing. We're going to provide a definition. I want to make sure that we cover any of those potentially unmitigated impacts. And so, Jeremiah, is there anything in there that you see that we may be missing?
Mr. Chairman, I don't have anything specific to suggest is missing in that definition here today. I did talk to a few of my members to see if this definition gave them significant pause. The general answer from those members was that it didn't, that these are generally things they try and follow, but that it would be helpful to have these. But that would be our intent, is to try and find those things for you as quickly as possible if we're going to go towards statutory construct.
Thank you.
Thank you. Todd, did you have anything to add? That your name was taken in vain on that question?
So, Mr. Chairman, yeah, I would just reiterate what Mr. Ryman mentioned. I think generally speaking, the definition, particularly the verbiage in paragraph C on line 11, page 6, I think those are the general items that we see impact assistance paid out for.
Well, Mr. Chairman, the reason, if I can just articulate it, the reason I asked that is the example that Jeremiah had given based on telecommunications within an area, and I don't know if that would fall into any of those within that definition, and I don't know if that's an issue other places.
You know, I guess so. Maybe we could ask Todd. I mean, because Todd gives some direction to the commission. I mean, when we look at the bill, it says for medical services, fire and law enforcement services, roads and public utilities. Is the example given was WildLink, a WildLink tower? Would that fall within the? Would that fall within that sentence?
Mr. Chairman, I think the closest thing that would cover that would be public utilities and how you define that. But typically public utilities are going to be your water and sewer type items, okay. But you could stretch it to make it cover the the WyoLink.
Okay, thank you.
And Mr. Chairman, if I may, real quick, if I remember WyoLink correctly, isn't that a communication tool for emergency services? So for medical and fire and things like that. So I do think it would fall under the definition that you have in there.
Okay, thank you. Senator Kinski.
Thank you, Mr. Chairman. A follow-up, I think Jeremiah had mentioned rulemaking, and in that regard, I guess I'd like to find out what additional rulemaking might have been undertaken by the council. And to pick up Co-Chairman Nicholas's narrative, since the time of the change of the funding formula and the run-up in the amount, this came to us. My recollection, it came to us with a request from you that we change the statute, and I think we told you you could do it by administrative rulemaking. I don't know what happened, but if you've gone from 100% to 65% of requests, maybe that conversation alone had a salubrious effect. But have you tightened up your criteria through rulemaking? And do you have the ability to adopt these things that are set out in the statute by rulemaking?
Director?
Mr. Chairman, I'm going to let Colin address the rules related to industrial siting.
Colin?
Yeah, so thank you, Mr. Chairman and Senator Kinski. So the council is in the preliminary process of doing rulemaking to their Chapter 1 rules, which covers the majority of the items in here. One of the primary things that they are looking at is to define unmitigated impacts. They do have a definition in their current rules, but it's very broad. And so we are in the process of looking at that. I would say maybe the one thing in the bill that couldn't be accomplished through rule is to change what the maximum amount of allowable impact assistance is. But I do generally think that the council has heard from the legislature and is trying to look through the requests of local governments a little finer and thus, reflecting the 65% that is typically awarded.
Okay, thank you. Thank you. Any other comments? Any other questions? Or committee, what's your pleasure with respect to the bill?
Mr. Chairman.
Senator Kinski.
Second. I'll second it.
Oh, who moved it?
Chairman Nicholas.
Mr. Chairman, okay, thank you. It was moved by Co-Chairman Nicholas and seconded by Senator Kinski. Further discussion or amendments? Senator Hicks.
Question on the bill on where on subsection D, where it goes into this exclusions, and then under I. Can somebody explain to me what that says? Because it seems pretty circular to me. I'm not exactly sure what it says or what it's trying to get. So.
Mr. Chairman.
Go ahead, Ted.
Thank you, Mr. Chairman. So excluded from the definition of unmitigated impacts down at the bottom of page 6 and on to page 7 are expenses related to improvements to existing structures beyond that necessary to return the structure to the condition in which the structure existed before the construction of the industrial facility. So if there's a structure that is impacted by the industrial facility, an unmitigated impact is not one that requires the local government to improve the structure beyond what it was before the construction of the industrial facility. That's my understanding of that language. So that's how I read it.
So Ted, if we look at it, so first question is a bridge a structure?
Mr. Chairman, a bridge is a structure, yes.
Okay.
So,
thank you.
Mr. Chairman, just to follow up on that.
Go ahead.
What about a county road that's heavily impacted? I don't know how this would apply to roads and bridges within a county that you can't, it just doesn't make sense to me. And maybe it's just the verbiage, but I can't figure out how this would work on a bridge and a road that you got to restore it back to the condition prior to the industrial project. I can't track. Maybe somebody else can, but it's a mystery to me.
Okay, thanks for sharing. So it's Representative Schwartz.
Thank you, Mr. Chairman. I'd like to offer an amendment on page 3, line 20, 21, and delete 2% and put it back, the part that's deleted to 2.7.
Okay, is there a second? Have a second from Representative Walters. Further discussion? All right, all those in favor of the motion to restore it to the original language of the statute at 2.7, as that's how I understand the motion, raise your hand. I see 3, 4. All those opposed, please raise your hand. 1, 2, 3, 4, 5, 6, and I would make 7. So that motion has failed. We're still on the bill. We're back on the bill. Are there any other amendments with respect to the bill? We'll let Senator Hicks go to work on fixing his definitional issues at a later date, maybe. Are there any other motions on the bill? Any other motions on the bill? Are you ready for the question on the bill?
Question.
Let's go ahead and take the roll on LSO 364.
Working draft number 0.4. Representative Kinner.
Aye.
Representative Larson.
Aye.
Representative Schwartz.
No.
Representative Simpson.
Aye.
Representative Stiff.
Aye.
Representative Walters.
Aye.
Senator Guru.
Aye.
Senator Hicks.
No.
Senator Kinski.
Aye.
Senator Steinmetz.
Aye.
Co-Chairman Nicholas.
Aye.
Chairman Perkins.
Aye.
Mr. Chairman, there are 10 ayes, 2 nays. Would you like this a House bill or a Senate file?
So, Mr. Co-Chair, this passed the Senate, or I mean the House last year, and it was a House JAC bill, I believe. So I think I would prefer that you guys work your magic on it first. Because
Okay, we'll I don't know if it's magic is what will work, but we'll work on it. So anyway, yeah, we'll go ahead and make that a Senate file. That's fine.
It's a voodoo of some kind.
Thank you. Next item on our agenda would be actually we've got the other industrial siding LSO 343 industrial siding division funding and fees.
Mr. Chairman, with the adoption of that last bill, I think we ought to just I would move that we lay this bill on the table indefinitely.
Okay, is there a second?
Mr. Chairman, question.
Let's see if there's a second. Let's see if there's a second first. We have a second from Senator Guru. Senator Kinski.
Is the title of the previous bill broad enough to admit of using Industrial Siding Council fees to help fund the Industrial Siding Council?
Well, maybe we should ask Ted that question.
So I think the answer to that, Mr. Co-Chair, is that you can change the title when it goes to the Senate Appropriations Committee, if you want to add that in.
Well, it certainly would change the impact. It sure would change the impact assistance payments. So anyway, I think you could change the title. I think it probably is broad enough. Okay. Senator Hicks, did you have something else?
Mr. Chairman, at that point in time, it just becomes a shell game. I changed what the other bill basically did was pull a percentage of the money out and put it in account, fully fund the industrial siding divisions. by doing this, we already fund them through general fund. You've recaptured the money one way or another.
Yeah.
So it becomes a shell game as to how you want to move the money to industrial siding. So it really doesn't need to be amended and that necessary, because it accomplishes the same thing, which was to get money back into the state's coffers. One was just to pay for industrial siding. Bill we adopted is more of a windfall for the state.
Okay, so we're on this motion to
Question
lay
on the
back
motion
in.
to table.
We're on the motion to table indefinitely. All those in favor, raise your hand. Appears to me that it is unanimous. Are there any opposed? Seeing none, it was unanimous. All right, so that's indefinitely, let's laid back indefinitely or tabled indefinitely. So now the next one we've got, I believe, is 389, isn't it? State group insurance.
Chairman, that is correct.
Okay, so who's going to take us through that one? Is that Ted?
Chairman, I can walk through the committee through this bill, Mr. Chairman.
Please.
All right, so this is 21 LSO 389, working draft 0.3. Title is State Group Insurance Contributions Community Colleges. Under current law in 93210, the state is obligated to appropriate for state employees and non-federal community college and UW employees enough funds to cover the employer share of the group health insurance premium. And what this bill draft does is it removes that obligation from the legislature for community college employees. So the legislature would be free to appropriate the amount it sees fit to the community colleges for them to cover the employer share of the group health insurance premium. Community colleges would be obligated to use those appropriations on that employer share, together with any other required contribution, which is language on page 2, lines 12 and 13. So the basic idea here is to provide more flexibility to the legislature in appropriating funds for the community colleges to cover the employer share of those health insurance premiums. And with that, Mr. Chairman, I'd be happy to answer any questions.
Thank you. Any questions for Ted, members? Representative Larson, go ahead.
Thank you, Mr. Chairman. And this may go back to the discussion that we've had is in this committee, and I'll ask Dawn to set me straight if I'm wrong there, where the community colleges come back, where, well, let me back up. Back when we done our austere cuts in the Meade administration, community colleges elected to take that out of their health insurance, and we allowed that, but now they continue to come back and say we're not funding healthcare as required by law. This bill would in effect correct that problem. Is that accurate, Don?
Mr. Chairman, that is accurate. The Community College Commission and the community colleges requested those austerity cuts, 8% cuts during the Meade administration, and they elected to take that out of the group insurance as opposed to out of state aid. And as a result of that, now the appropriations bill is arguably in conflict with the statute, as pointed out in the community college budget request as recently as this year.
Okay. Thank you. Senator Kinski, did you have something? That was the same question? All right. Any other questions?
I move the bill.
All right, we've got, well, before we do that, is there any public comment on this bill? So Dr. Caldwell. Welcome.
Thank you, Mr. Chairman and co-chair members of the committee. I am Dr. Sandy Caldwell, Executive Director of the Wyoming Community College Commission. And I also have with me Mr. Larry Buckles. I saw him just a moment ago. He is the CFO for the Community College Commission. I just wanted to hit a couple of points on this one. We did seek guidance from the Attorney General's office related to this language. Primarily the concern that we had was the separation of the community colleges, but certainly understand the history that brought this forward. In the appropriation that came forward in this year, we did acknowledge we were not coming forward with a request on health insurance because we did in fact agree to those cuts when they were first imposed prior to my arrival. What we found from the Attorney General's office, or the guidance that we received, is that you're actually okay within your statutes, specifically 93210B, that outlines health insurance for two reasons. One is that as a legislature, you do have the flexibility already, whether or not to fund or not. So this would provide clarification, but does not change, according to the Attorney General, the ability for you to already do that. The second part of that is we do provide the full information, and then the cut is applied to that. So I think it's a technical aspect on that we do in fact submit the full amount, and then the cut is applied to that. So in the most technical aspect of it, this actually, you actually are meeting that, and then the cut is applied afterward. And then I also wanted to note that we do have rules for this for the Community College Commission. It's been spelled out for many years. Should there be a shortfall, how we administer that. And those rules have been promulgated for quite a long time, and they actually work very well. So that was what the guidance that we received, is that you are actually okay, and that through the technical process, we actually meet this. And then should you desire to have some clarifying language within this, we would be happy to help and assist in any way that doesn't make it appear that there's a division between the community colleges and the university, when we know that this isn't the point here. This has to do with the ability to reflect the current practice. I don't have any prepared for you now. And the reason I don't is because I would like to make sure that any simpler language doesn't have any unintended consequences. We don't want to intentionally create an obligation on EGI or anything like that, that it really does meet what it needs to. The Attorney General person for the commission feels confident that we could come up with something like that that would make it much simpler if in fact you wanted to include some clarifying language.
Thank you, Dr. Caldwell. Any questions for Dr. Caldwell? Any questions for Dr. Caldwell? Mr. Buchholz, we're glad to have you here today. It looks like you and Dr. Caldwell have the same picture in your house. But anyway, did you have anything to add, Mr. Larry?
Thank you, Mr. Chairman. The one thing I would just elaborate on a little bit more is to add some more clarity what Dr. Caldwell described as our budget request. The statutes require us to submit to the budget office a budget request, and that budget request does include full funding for community college employees, just like it does for every other executive branch agency. From that request acknowledges and documents a reduction to that amount in the amount of community college life insurance, or I'm sorry, health insurance that was included in the budget clear back in 2003, when the state paid $225 as a flat fee for every employee. That amount is built into state aid. For the community colleges, that amounts to $7.57 million. We take that off the top of the calculation. Then we apply that sustainable reduction that we've talked about that happened in 2016 during the Meade administration. We take that off. The remaining amount is what we ask for an appropriation. So we acknowledge it, we comply with statute, we submit the budget request as it's laid out, and what you get at the end is a budget request that takes into account both of those reductions.
Thank you, Mr. Buckles. Any questions from Mr. Buckles? Senator Kinski.
For either him or Ms. Caldwell, I thought what I heard you say, Sandy, is that you're already doing what this bill requires, either by practice or through rules. So effectively, it wouldn't make any difference whether it passed or not. Is that right? What's the harm that's to be avoided by opposing the bill?
Mr. Chairman and Senator Kinski, we are already in compliance with the current existing statute. The concern that we have with the way that the bill is written right now is that the perception that there is some division with the community colleges and university, that this is not intended to communicate. And the AG did share with us that you are correct on you are following the statutes, and through the technical process that we have, we actually do fulfill the current statutes the way that they are written.
So, Mr. Chairman,
Senator?
Not either for Sandy, I guess this would be for staff or a committee member. Why do we even need this bill? Can somebody tell me why we're even talking about it? What am I missing here?
Representative Larson.
Thank you, Mr. Chairman and Senator Kinski. I'm scratching my head because I've said in these appropriation meetings with the community colleges come before us the last several requests where I've been left that it is their impression that we're not complying with statute in funding their health insurance. And today I'm hearing that now, and so is that, I guess I'm asking the same thing. And so is this a new revelation to the Community College Commission that we have indeed been in compliance, or same question?
Thank you, Sandy. Go ahead, Doctor.
Mr. Chairman, Representative Larson and Senator Kinski, you are correct. We were incorrect in making that assertion, and we did seek guidance from the Attorney General. I don't know if that didn't happen in the past. That was prior to my arrival. However, in the last budget request, we did not bring forward a health insurance request, and in fact acknowledged at that time that we knew that shortfall was there. We were not making a request. We know that we were to have taken that. So you are correct that that you had the authority to do that all along, and that was not seeking initial guidance from the Attorney General from the Commission.
Okay.
Mr. Chairman?
Yes, go ahead.
Mr. Chairman, not currently. We're working well with the community colleges, but in the past, this particular statute has been presented to us to say that you have to fully fund. And through the process of what took place in 2016 with the austerity cuts, there was we were asked to use that statute to bring him back that $7 million. And we worked back and forth on it, but right now, we're in play, but I'm not certain that those people that take our roles in the future won't assume again that there's an expectation to fully fund this.
Thank you. Thank you, Kevin. So where are we? Mr. Co-Chair?
Well,
you have something?
Yeah, thank you, Mr. Co-Chair. I would just point out that basically I appreciate Dr. Caldwell's inquiry into this, but that doesn't mean another community college sometime might use this argument other than the commission using the language. And in addition to that, this broadens the scope of the statute. And so it actually improves the statute because it treats us like other state employees. And so in that sense, it's probably just the right thing to do. So thank you.
Thank you. Is there any other public comment on this? Karen, is there any other public comment? Patricia, Director Bach, hi, how are you doing? Do you have comment on this?
Good afternoon. I would just, Chairman and Co-Chairman, like to reiterate
what Director Hibbert said, and I would agree with him that depending on what happens in the future, I think that having something like this in statute would be helpful.
Thank you, Director. I thought I saw a hand from a member of the committee. Representative Schwartz.
Thank you, Mr. Chairman. So I will confess I had a tech failure and got distracted during Dr. Caldwell's presentation, but I heard you mention that you thought there would need to be other statutory changes. And if that's correct, what were you alluding to?
Thank you. Dr. Caldwell.
Mr. Chairman, Representative Schwartz and members of the committee, what I had stated is if you do want to have move forward in some sort of clarifying language on this, we'd be happy to assist with some language. I would want to seek a little bit more guidance. We think a more simplified approach would be helpful that doesn't create a perception of a difference in the colleges and the university just for these purposes. So we would be happy if you do want to include clarification, some language that may be simplified the way that this is written, that makes sure that it achieves your outcome without also having other unintended consequences.
Okay. That take care of it? Karen, was there anybody else?
Mr. Chairman, moments ago, I did hear from someone, but I do not see them in the waiting room at this time.
Okay. Thank you. I think that then we'll conclude public comment. If that person shows up, we may entertain them. So committee, what's your pleasure on the bill?
Move the bill.
Moved by Representative Larson, seconded by Representative Walters. Further discussion? Let's go ahead and take the roll on the bill then.
Mr. Chairman, members of the committee, the motion is on 21 LSO 0389, working draft 0.3, state group insurance contributions, community colleges. Representative Kinner.
Aye.
Representative Larson.
Aye.
Representative Schwartz.
Aye.
Representative Simpson.
Aye.
Representative Stiff.
Aye.
Representative Walters.
Aye.
Senator Garreau.
Aye.
Senator Hicks.
No.
Senator Kinski.
No.
Senator Steinmetz.
No.
Vice Chairman Nicholas.
Aye.
Excuse me, Co-Chairman Nicholas. Chairman Perkins.
Aye.
Mr. Chairman, the bill fails.
Okay. Next item for our consideration would be LSO 367, longevity pay.
Mr. Chairman?
Yes, Co-Chairman.
I would move to table the bill indefinitely.
Okay, is there a second? You have a second from Senator Garreau. Is this one, we debated the last one, or at least discussed it. Is this a non-debatable motion? I guess that's my first question.
It is.
I think it is. So, all right, we've heard the motion. All those in favor of tabling this bill, raise your hand. Let's see, 1, 2, 3, 4, 5, 6, 7. Huh. All those in favor, all those opposed, raise your hand. I see 1, 2, 3. Okay, so that motion has passed. So that bill is tabled. With that, that concludes the items on the agenda.
Mr. Chairman, was that motion as to the merits, or was it just desire to be done? Because Co-Chairman Nicholas said he was going to have us out of here by
3 o'clock.
Yeah, well, you know, there's no provision for overtime on legislative pay, so it doesn't make any difference. So anyway, with that, that concludes all the items I have on the agenda. Don, anything that we need to wrap up or clean up before we conclude our meeting today?
This means I can get a haircut today.
Mr. Chairman, I do not have anything else on the agenda today. The committee might be thinking about whether or not you wish to sponsor bills individually or as a House and Senate committee or as a joint committee. There are a couple of bills that are still hanging out there. One was referred to this morning, the IT effort. There was a working group led previously by Representative Olson that may have one or two bills related to the consultant study, Barry Dunn. In addition, I believe there was a working group that has met. I believe that was Representative Larson on the House side and Senator Steinmetz on the Senate side regarding the governor's authority for appropriations and expenditures during the interim, or B11. That bill is still out there for potential consideration. I believe that is all of the legislative bills that JAC has contemplated. I think there are some individual members who would like to take individual bills to JAC for potential co-sponsorship or sponsorship. But I believe those are the three bills that JAC has not cleaned or cleared the desk with.
All right, thank you, Don. Appreciate that. Mr. Co-Chairman, any items of business you'd like to bring up?
No, I'll go, both the IT bill and the governor's authority bill are fairly important, I think. And so however we get to it, I think that we'll either if we circulate them and just for signature, or how we do it, or if we have another meeting, or if we have a quick meeting at some point immediately in March to get those out as soon as we've got completed drafts. I think hopefully that will happen. That's really all I have.
Okay, thanks. Anything else from any members of the committee that for the good of the committee? With that, there being not appearing to be any, just members, thank you for your attendance today. Staff, thank you for your attendance today. Former Senator DeCarey, I think we probably took care of your concern already. And if there's nothing else, going once, going twice, the JAC will stand adjourned.